Welcome to Legally Speaking with me, Tarun Nangia. Today we discuss an issue that is important to all the top promoters of India, largely all businessmen, that the Karnataka High Court has held that use of black money law retrospectively is unconstitutional. This ruling assumes importance given the fact that Indians have been holding accounts abroad since many decades. And of course, if they are unduly harassed or prosecuted, then of course it troubles the business sentiment. Given that, as a fact, the ruling of the Karnataka High Court is important. Today, we have three experts who will discuss the impact on industry and the good impact of this decision by the Karnataka High Court. Let me welcome Justice Arjun Kumar Sikri. As you all know, he's India's leading arbitrator. He's also a judge of the Singapore International Commercial Court and previously the judge of the Supreme Court of India. Good to see you, sir, and looking forward to some interesting insights. We have with us Mahesh Agarwal, managing partner of Agarwal Law Associates, India's leading litigation law firm at the Supreme Court. We also have Ruby Singh Ahuja, senior partner of Karanjawala and Company, a leading law firm, litigation law firm at the Supreme Court of India. Good to see both of you and looking forward to some interesting insights from both of you as well. At the outset, let me request Justice Sikri to give an introduction into the background of such actions. What does it lead to? How does it impact the business sentiment? And why such a Supreme Court ruling is welcome. Over to you.
Yeah, thank you, Tarun. And I entirely agree with you that this judgment of Karnataka High Court has decided a very, very important issue. And if I may say, it's a balancing between the two competing interests, and both are equally important public interest. There's no denial of the fact that black money, yes, it's a taboo, it's a menace. No doubt about it. We remember way back, I think almost maybe 20 years ago, 15 years ago at least, Mr. Ram Jetnani had filed public interest litigation in respect of black money, and that all that black money which is there in various other countries, it should be brought back and all that. And as I said, that everybody would say it affects the economy badly. If black money, and particularly when it is stacked and kept outside, because the economy, our own economy is deprived of such valuable money which can be used for many, important purposes. It can, industry can grow, employment can grow, many other public projects can be undertaken, etc., if this money is available. Now, that was the reason that black money, undisclosed foreign income and assets and imposition of tax 2015 was passed, which we may in summary call it as Black Money Act. Now, that is one part of it. And therefore, the act which is passed is with the this objective, which is a laudable objective, there's no doubt about it. But the question which we are discussing today is that, look, in this act, there's a provision that it is made keeping it outside and not disclosing black money and keeping it in accounts outside India is also, apart from its tax implication, etc., is also made as a criminal offense. Now, question which arises is, can you make a particular act as an offense and give it retrospective effect? That although this act has come in 2015, as I said, but can we say that what happened in 2005, 6 or 8 or 9, and if somebody had done this act, had kept the money outside and had not disclosed, etc., he has committed an offense. Now here, that is what I'm saying, this ruling makes very important, and therefore, just first on principle itself, making a particular act as a crime or a criminal act, Parliament has every power to do so, but you can't make it retrospectively. That suppose, I give very, very simple example of theft, so that people may understand that. Suppose theft is not a crime, or because people may say why theft should not be crime, I take another example, bigamy. As far as Hindu Marriage Act is concerned, Hindu are concerned, before 1955, they could marry any number of times. They could have any number of wives. It is only in 1955 that or 56, when the Hindu Marriage Act was passed, it was said that no, when this monogamy was introduced and there's no bigamy, there can't be any polygamy, etc. So a person who had married in 1952, 53, before that, and he had married twice or three times, you can't today say in 1955 we are passing this act. And therefore, since you have married twice or thrice, it becomes a criminal act and you will be punished for that. So therefore, yes, this Black Money Act, laudable, but when it comes to criminal implication and making a particular act as a crime, it cannot be from back date, because the day on which a particular act was committed, law was very clear, it was not treated as crime. So it is this aspect which has been decided by the Karnataka High Court. And if I may say so, this is predicated on, and the court has primarily, of course, apart from other reasons, pressed into service provisions of Article 20 of the Constitution. And Article 20 is very clear about it. It clearly says, Article 20, in respect of criminal acts, etc., places, because it's Article 20 is in the, first of all, we have to know this, that it falls within the chapter of fundamental rights, which are granted to the citizens of this country, or many rights are available to even non-citizens. Article 20 is regarding even because it uses the expression no person. So person can be not necessarily an Indian, he can be non-Indian also. And so therefore, first right which is stated, because second right say double jeopardy, for same offense you can't be punished twice. Then there's another right which is self-incrimination. Again, self-incrimination, I can't be a witness against myself. Nobody can force me to give a witness against myself. That I can't be forced to do that. But more importantly, what we are dealing with is the first provision of Article 21, sub-article 1, which clearly says that no person shall be convicted of any offense except for violation of a law in force at the time of commission of the act. So that it can't be treated an offense, and I cannot be convicted unless there is a law in force at the time of commission of the act charged as an offense. So therefore, and the principle, as far as it is concerned, we know that we have the courts have the power of judicial review. That means, and judicial review is not limited to the executive act of the government. It extends to the judicial review of legislation as well. That means any law which is passed by the parliament or the state legislature can be challenged. There are few challenges available. One challenge, but more important, is that it cannot be in violation of any provision of the Constitution, because Constitution is the supreme law. And every law passed by the parliament or any legislature has to, and that is a subordinate law which has to be in conformity with the constitutional law. And therefore, this act making it, Section 72, making this of the money, this Black Money Act, making up a particular offense as retrospective, is clearly in the teeth of Article 21. 20 subclause 1 or subarticle 1. And that's the main crux of this judgment. And on the basis of that, the court has ruled that this could not be, those persons who were against whom the notices were sent for prosecution and they had challenged, so those were set aside by the court. And they said, and it is, as you rightly mentioned and said, that it would be a big at least relief. It comes as a big relief to the business community, because I today may arrange my affairs, economic affairs, etc., keeping in mind what are the laws prevailing today. And not that after 5 years, today I take a particular act, after 5 years a law is passed, dubbing this particular act, which I have taken 5 years ago, no, it is a crime and it will relate to that as well. And if I may say so, this is based on, this Article 20 also is based on, it was stated by the Supreme Court way back in 64, and on the basis of, and I'll conclude with this, my initial remarks, Palkiwala said a very nice words about it. This is a rule against retrospective taxation. It was in the context of taxation, is founded on elementary considerations of fairness. No one ought to be punished for an act that was not punishable when it was done. To do so would be to infringe the principle of legal certainty and predictability, which is at the heart of rule of law. So three things which three messages which come from this statement are that fairness demands that I cannot be punished for an act which was, when I committed that act, was not prohibited by any law. And that is also based on, the second is legal certainty and predictability. If in future something is going to happen and which is going to castigate me for what I have done today, it is against predictability and certainty. And third is, which he said, that it is at the heart of rule of law. So it is the, rule of law enshrines this principle, which is contained in Article 20, sub-article 1, and on that, but this judgment which is passed is really a welcome move.
Thank you for that explanation. I remember in the last show, you also shared some anecdotes and economic theory of law in another context. That was also indeed very enlightening. I'll take this to Mahesh Agarwal, Managing Partner of Agarwal Law Associates, for his intervention on this topic. Over to you.
The first thing is that, this act is called the Black Money Act. A lot of people are confused. What is the meaning of Black Money Act? Does it mean black money in India or abroad? So we must clarify that this black money is relating only to foreign accounts, foreign assets, and it has nothing to do with any black money issue in India. Now, prior to this act, there was no sentencing or prosecution under the IT Act for holding an account abroad. For the first time, this draconian provision came, which provides for sentencing of a minimum of 3 years up to 10 years. So it has been made an offense, and this punishment has been created for the first time. So one can arguably say that if somebody had an account outside India in 2007, when this punishment was not provided, he cannot today be punished with a new law for a period of 10 years. So two things: A, it has been created as an offense, and this punishment has been created for the first time, which is 3 years to 10 years, plus 3 times penalty, plus 30% tax. It's a really draconian provision, and it had shaken up the entire business world in India. Somehow or the other, India has had business relations with many countries. All businessmen have had accounts abroad. Some were declared, some were not declared. Now, this particular situation in this Karnataka case was very peculiar. The account was opened, say, in 2008 and 9, and the account had been closed prior to 2015. So as on the date when the act came, there was no account, there was no money abroad, nothing. So it could not be created as an offense. So the court has correctly held that on the day when the act came, there was no event which could be called an offense. Now, as to whether this will be extended to a situation where an account has been created, say, in 2008 and 9, it remained in existence in 2015 and has been closed, say, after 15, what happens to that case? It can be argued that account was opened on a date when there was no law and it was not a punishment, and therefore retrospective application cannot happen. It can also be said that on the date of 2015 when the act came, since you had an account and you had money abroad, you have to be prosecuted. But this issue is yet to be tested. What has happened in this case is the account had opened and it was closed. So at least insofar as everybody in India who's concerned with accounts which were opened and closed prior to 15, they can give a sigh of relief. Now, there are multiple petitions pending in almost all high courts all over India raising the same issue. Now, this is a very important judgment, and we hope it will be followed by other courts and accepted by the Supreme Court also.
Thank you for your intervention. Indeed, a very important in a sense, list of demands from the business community so that there are no hurdles to doing business with notices from the income tax department, then go to court, get a clarification. I'll go to Ruby Singh Ahuja, senior partner from Karanjawala and Company, for her intervention on this topic.
Thank you, Tarun. See, firstly, the thing is that, you'll have to see this whole concept of black money under Indian context. As Mahesh said, this act is called Black Money Act. Now, black money, the word black money has some serious connotations in Indian scenario. It also, somewhere society also takes it in a very different way. Now, when you prosecute somebody under this provision of Black Money Act for a sheer offense because somebody had opened a formal official bank account at that time, and you want to tell that person that, look, 20 years ago, maybe you opened a bank account for some 30, how far will you go? Will you go 20 years back? Will you go 30 years back? And somebody has opened a bank account, which in this Karnataka case, which was closed, was not there. I am going one step further. Let's presume it is there today also. What will happen to that? Because when that account was opened, it was a purely legal act. If we start prosecuting people like this, giving retrospectivity to a form, retrospectivity to an action, and then say it is illegal, you didn't know when you opened it. So now you want to say that 20 years ago you opened it, it is illegal. Then I think the basic principle that Justice Sikri used, that fairness and equity on which our legal system works, that will be given a go by. And I also want, one point I also don't understand, both the panelists have spoken on the other issues, that when legislature enacts an enactment like this, which on the face of it, very, very vulnerable, its validity will be doubted at the first pretext. Everybody will go to court and say it's a very basic principle. It is against Article 20 of the Constitution. There will be 100 people who will go to court. What I don't understand, the objective of making an enactment like this. I personally feel that when the enactments are made, something like this, which on the face of it will never pass the scrutiny of any competent court of jurisdiction, it's better that this makes the law vulnerable. It puts citizens to jeopardy. It asks them to go to court to unnecessarily litigate. Even government has to unnecessarily litigate now. I am very sure, I don't know whether, I haven't checked whether this judgment has reached Supreme Court or not. I'm very sure this judgment will go to Supreme Court. There'll be another 2 years of litigation to this. Mahesh says that there are cases pending all over India. So everybody's arguing a principle which on the face of it cannot survive. Because what are you telling somebody? You're telling somebody that you have committed an offense which at that time was not an offense. You basically, I personally feel that such actions, when you take, and that also penal provisions, criminal law, the legislature also needs to be little careful with what they're doing. It also affects people's wealth, their expenses, their time, human resources of court. And somewhere the whole stigma also comes कि भाई आपको तो Black Money Act में prosecute किया जा रहा है, for a very valid money kept somewhere.
In fact, the last statement made by you, Ms. Ahuja, was very important because industrialists have been indeed speaking that newspapers highlight their names, saying that so-and-so industrialist booked under Black Money Act. Exactly. And they feel the bankers start calling them, people are scared to deal with them for a very innocuous thing. They say it's a simple issue of a bank account. Another industrialist from Karnataka issued a statement that her husband is a foreign national and the bank accounts were opened decades ago. So very valid point that, a stigma gets then attached for no reason. And a case also gets foisted on him and he has to fight. I'll go to Justice Sikri at this point. Sir, if you could clarify also one thing, that in Bombay recently the court had made such a ruling. Now you see the Karnataka High Court also did one. And with what Mr. Mahesh Agarwal said, that there are many cases, is there a case for the Supreme Court to club all these matters and take it up at the Supreme Court level? Or do you think it will take its own sweet time with various cases happening over the country and then coming?
I think it's a very valid question. Many times Supreme Court has undertaken this exercise. when particular enactment is challenged and constitutional validity is challenged and the issue is pending in various high courts. And as Ms. Ruby Ahuja has rightly mentioned that possibly and most likely appeal would be filed, and ultimately it is for the Supreme Court to decide. So everybody knows that in such cases, and particularly where the validity of legislation comes into question, the matter lands up to the apex court, highest court, and therefore. Suppose against this judgment only Karnataka High Court, when the appeal goes and the court comes to know that there are many cases pending all over. It is not for the first time, but it has happened many times in the past that the Supreme Court then would withdraw all those cases so that in one go all these judgments are decided. And I may add one thing: the two particular aspects which are pointed out, one by Mahesh and other by Ruby, and they bring a nuanced approach to this particular issue before us, and which was although not in this case. As Mahesh rightly pointed out here, the account was opened and even closed before that. What would be the position in case the account continues? And if the account continues today, and whether, and once this act has come, whether it becomes a responsibility or liability or obligation on the part of that account holder to know, at least now disclose because it has come. Second aspect which Ruby raised was that, look, the account was opened at the time when there was no such prohibition, etc., and therefore account was validly open. But I will put one caveat to that. When it comes to taxation, it may not be, we have up to now discussed about the criminal consequence. But if I open an account, whether within India, I have opened an account, put some income there, but has not disclosed that, then I am violating the provisions of Income Tax Act because I am not disclosing that. So it becomes black money in that sense. Likewise, even if I had earned income, I'm Indian citizen, Indian resident, because under the Indian Income Tax Act, we have the concept of resident, non-residents. So if I'm an Indian resident, I have to file return in India with the income tax authorities. So if I am an Indian resident, I'm supposed to file a return in India, but I open an account outside, some income is generated, and I don't disclose that income. So even before 2015, as far as income tax is concerned, I was avoiding that income, rather evading that income. So in that sense, under the Income Tax Act, the violation had taken place that I had not disclosed that income. So therefore, one of the purposes was this also, when it says, and I may read that name of the act again, and that is the purpose: black money, undisclosed foreign income and assets. So even if I have, as a citizen or resident, earned income outside, like I give you one simple example. Today, as an arbitrator, I have many international arbitration where income comes to me in dollars or in pounds if I have done it in England or somewhere else, or in, say, Singapore and somewhere else. But the moment that amount comes, that is remitted, I have two options. I open an account outside and keep it the money there, but that is again contrary to the provision of FEMA, because under FEMA, I think Section 8 says that I am supposed to bring that money within India and disclose it here. But in any case, I have to disclose it under the income tax and show it as my income and pay income tax on that, which we have to do. So therefore, even before 2015, if such an act is committed, then from income tax point of view, the income tax was not paid. So whatever remedy is available under the Income Tax Act, that can be done. That is one aspect. So we are not concerned with that. That is what Ruby had mentioned that. And again, coming back to what Mahesh Agrawal said, that about that, yes, it is still, we are still in a gray area what court decides. If account is there, account continues to be there, and act comes into force, whether now it is my obligation to disclose that, because it says about foreign income and asset also. Today, in the form of that money lying there, is my asset as well. And therefore, if I have to, and imposition of tax on, because if the act, purpose of the act is that even today I have to disclose and pay tax on that. And if I don't pay that tax, then it becomes, because there's one another I mean, legal parlance, we come with another doctrine or other concept. We are here talking about retrospectivity. No act, and particularly criminal offense, cannot be made retrospective. That is what we have discussed so far. But there's another concept of retroactivity. It is this: if there is some say so-called offense which has become offense now, was not an offense but continues to be, and the cause of action, or that it continues to be an act even after that act, then it may become. So on that today, because for want of any facts before us or anything before us, we can't say that. And Mahesh has rightly pointed out, it will have to be determined in some case. But as far as this case is concerned, it was very clear that account was not only even opened but closed even before that. And then when it comes to criminal prosecution, sorry, you cannot do that. What can be the other implication about tax, etc., and that too under the Indian Income Tax Act and not under this act, may be a different aspect altogether. And again, repeating to what you said, that yes, court has the power, Supreme Court, and may call upon call all these cases to itself and decide it in one go.
Thank you for explaining this aspect to us. I'll go to Mahesh Agarwal at this point on the same question of the case. Is there a case for clubbing these matters? And what is the future path given prosecutions are happening in different states of India? Many times the account holders are inheritors of an account who may not be updated in law. In many cases, wives inherit these accounts in case the spouse, all of that.
No, so I'll tell you what has happened is there was a complete outrage when this act came. Of course, it has come with a noble purpose, and nobody can defend anybody keeping black money outside India. That can be nobody's argument. But there is complete lack of clarity, and it has wide sweeping ramification on many innocent people. Now, as you know, Indians have relations abroad, they have families abroad, and there are situations where one brother is outside India, one is inside India, or there's a father-son, father-daughter relationship. There have been cases where it's a joint account. A is a NRI, he can definitely open an account abroad, there can be no question. For inheritance purposes or a nominee purpose, he gives name of his brother who's an Indian. Now the brother doesn't even know that his account name has been given. Under this act, since he's an account holder, he can be prosecuted and sentenced to a minimum of 3 years. Now this is the draconian impact of an act on completely innocent people who have no idea of what is going on abroad. There are also business families where the patriarchs, the promoters had accounts abroad. And like you said, by way of inheritance, they have named somebody. And suddenly after 20 years, somebody gets money from outside, he can be prosecuted. Third, very important aspect under this act is that it also applies to beneficial owners. Now, a beneficial owner is not defined under the act. It is open to many definitions under various acts, whether it is PMLA, Companies Act, IT Act, there are various definitions. Now, beneficial owner can be a person, somebody opens a trust. A and B have opened a trust, and he gives name of Mr. X, that he is a beneficial owner. To be a beneficial owner, you don't even need the consent of X. So X doesn't know that he is a beneficial owner. He has not contributed any money. He has not signed any paper. He has not sent any money abroad. He has no connection with any deposit, but he is a beneficial owner. Now, if this act is strictly applied, then that innocent beneficial owner who has been named in a foreign account will be dragged in and prosecuted. So if you see so many names and outrages because of that, most of these people who have very high reputation have got embroiled in unnecessary harassment without anybody applying his mind as to whether there was an offense or not. There is no show cause before, the names have been flashed in the papers without any remedy to the person whose name is defamed. So there are genuine cases where a person's name has been used abroad without anybody knowing. Now, all these issues will slowly come up. And these are very serious issues that can a person be damned or prosecuted for nothing done by him just because the act is so wide sweeping that it takes into fold anybody. So these are serious issues which will slowly be resolved.
That's a valid point, and you made a couple of valid points on your intervention. Let's see if the Supreme Court take all these issues up. We'll go to Ruby.
No, I may interject and add.
Yes.
Actually, as you rightly pointed out, these examples which Mahesh has given are very valid example, and innocent persons are roped in. Instead of, as he has said, that over a period of time these issues will come to the court. Why not, as a fair legislature, the legislature should intervene and make suitable amendments by safeguarding such persons who are innocent.
To stop this harassment.
Yeah, to stop this harassment. Yeah.
That's a fair point. I'll go to Ruby Singh Ahuja, Senior Partner, Karanjawala and Company, for her intervention on all these issues.
Tarun, I was going to say what Justice Sikri just said, that look, and Mahesh kept on some loopholes in the act. I can understand sometimes new acts come and there are loopholes, and the creases are ironed out as the time passes by. But this particular situation of retrospectivity is not a loophole. It is, the validity is not there of this law. It will be struck down, according to me. I will be surprised if this judgment is, set aside by the Honorable Supreme Court. And I think, as Justice Sikri rightly said, if there are so many petitions pending, it's not the question of harassment. For a moment, let's forget harassment. For a moment, let's forget that people's name are being, you're putting a stigma when none exists, as you gave an example of a businesswoman from, whose husband had an account. So there are many such cases, and everybody has a justifiable reason for opening. I think before this matter goes to Supreme Court, and I think state exchequer also spends money on lawyers, spend time of the judiciary, it will be well advised to at least look into this, come up with some sort of an amendment. It's not rocket science. It won't take too long a time. You may have to put some 2 subsections somewhere or a proviso, and it can be done. But if the government wants to take it right till the Supreme Court, I mean, Justice Sikri is there. I'm very junior to him, but I can say that I doubt this will be sustainable in court. So I think and one very important thing, I think government should also
echo your sentiments.
Thank you, sir. And government should be mindful of this. In India, still defamation is not taken very seriously. Some big businessmen whose reputation is being tarnished, and society में कि आपके ऊपर black money का case चल रहा है. I mean, why can't he sue? Why can't he sue the government? I mean, anybody can sue, because what you're doing, you're defaming something which that person has not done, and it's a criminal offense. Criminal offense basic is...
I think that it may not be, such a move may not be possible, because it is an act. So you can't say that the provision of act is set aside. That's a different thing, but it can't lead to defamation.
So the point is that you are tarnishing reputation. I think that we are having this discussion today, and all these big
that government should be conscious of the fact that this is the effect, which is very wrong effect, and on the business, on the society, and therefore government should itself take remedial measures. To that extent, I agree with you. Yeah.
Thank you. The reason why we discuss this is also because promoters also face harassment, because they have been telling me time and again that by virtue of holding a foreign bank account itself makes us look like a criminal, as if holding a foreign bank account is a problem. Yes. And we are somehow shady people because we have foreign bank accounts.
Exactly. You're clubbing them with criminals now. Basically, you're clubbing them with criminals now.
So they are saying, what is a legitimate business activity of having a foreign bank account to do business or to import, export, or any such business, makes them look like a criminal, with people seeing them as smugglers or something. So they say that even very respected businessmen have a problem that their names are flashed in the press with this kind of a taint. We hope that there will be some direction from the Supreme Court in this regard. This pertains to some of the most respected business families of India who have been holding accounts, and for education purposes, there's so many. They have been doing business, earning foreign exchange for us Indians and for the whole of the country. That's why this is important. We'll take one final comment from Justice Sikri as we end the show.
Okay, I just to say what you are saying, that let me give you my personal example. And you see, as I said, that as international arbitrator, I am earning foreign exchange. At one point of time, I was thinking of opening a bank account outside for simple reason. I tell you, practical reasons. When that foreign exchange comes and it is deposited in the bank account here, bank deducts its commission on that, which is, not like for preparing the bank draft, etc., some minuscule amount. It is good commission, they say. So I'm deprived of that amount, even when I'm receiving that amount. Not only that, when for attending that particular case, when I have to go out, naturally I need foreign exchange. And for the purpose of, say, suppose I am in London or I am in Singapore, I have to stay in hotel, I have to incur other expenditure, etc. there, which is paid to me, and on which this, as I said, that when I deposit here, they charge the commission, and then I'm now forced to take foreign exchange for spending it there, on which again I pay. So I'm paid. So I thought that why not? I should have a bank account. At least my expenditure, I did it, do it from there. But then I decided against that. But I am affected. What I'm saying is only this. So maybe for very genuine reasons, many businessmen are having, as rightly pointed out by the other two panelists, that many very genuine reasons, many are having the foreign accounts. Yes, they are supposed to disclose it now, particularly after this act. It should not be, income should not be suppressed. Income should be disclosed. But then it should not lead to these draconian consequences which we are now facing today.
Thank you for that final input, and also your anecdote which you shared with us. Given the seriousness of the issue and the kind of people who are being troubled by it, we may have to take up this issue again, because the final word is not out on this one, and there will be prosecutions, there will be cases. Finally, I think the Supreme Court ruling is what we all look forward to. So we do one more show on this, but for this moment, I would like to thank Justice Arjun Kumar.
Maybe the legislature will listen, watch your show and make amendments. Maybe the Supreme Court is not troubled.
We all hope so for that to happen, and it will be nice to do a show on that too. But let me thank Justice Sikri, Mahesh Agarwal from Agarwal Law Associates, Ruby Singh Ahuja from Karanjawala and Company for speaking out on this important issue which concerns the Indian economy and the businessmen of India. Appreciate your joining us. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.